Hello, fellow Toolboxers. Welcome to episode number 345 of the Immigration Lawyers Toolbox podcast. We're having a great one. We're a regular monthly interview with Kevin A. Gregg Esquire, partner at Kurzman, Tenzelli, and Pratt. His name will be stuffed in the back of their homes hopefully someday soon. And we're going to talk about federal litigation updates. And I've been doing a lot of study on that because I, for some reason, did a consultation about, immigration kind of case. So I have to sit and study federal law, and so it's always fun learning new stuff. But having said that, I want to thank our special sponsor, Serenade eImmigration by Serenade, the all-in-one software so many immigration lawyers and firms are happy with using for not only their but also different aspects of their business, from invoicing and a lot more. They're always expanding and doing more. A great company. If you want to learn more about them, go to serenade.com. I'd see Serenade with the C, and do a video, a practice session with them. Download it, test it out for yourself. They got a good team over there that can really help you out, and I appreciate the work they do. Now, if you're part of the Immigration Lawyer Toolbox community, I just published a white labeled PDF, or it's a Word document, PDF that I use my firm, but I gave to Toolbox that lists all the bona fide document checklists that we give to clients and say, hey, try to get 5 or 6 of these. Streamline your practice. Download for free on our circle.so community page. If you're a lawyer, just email me with your bar number. You can download it. We also have our own I-693 checklist that we send to clients as well. There's CLEs we've done about D3 waivers, about extended absences and keeping the green card. Help you get Kevin on to talk about some of this federal litigation stuff on a CLE level. We'll set that up. Just email me info@immigrationlawyerstoolbox.com to get access. It's free, and it's just mind-blowingly good information that we're sharing with the community. Having said that, none of the information here is intended as individual legal guidance. Please consult with an immigration attorney for your case. This is not intended for regular people. It's a trade podcast for immigration lawyers. So let's bring our good friend on board. Good to see you, Kevin Gregg. How are you?
Good to see you too. Do you consider me a fellow toolboxer? I want to be considered a fellow toolboxer.
Oh yeah, you're a professor in the game right now. You're a professor in the immigration toolbox. Yeah, you're like a wrench. You're a hammer or a wrench. I'm not sure.
I'm sorry. Right. The metaphor or the analogy. Would I know? It would be a metaphor. Okay, I'll be the wrench and I'll be the wrench in the toolbox. That sounds good.
Very
good to see you as well.
Good to see you, bro. So, one thing everyone knows, you're a dad now. So you got not only you're traveling the country protecting immigrants, but also protecting your child from sleep and all that stuff.
The child's protecting me from sleep. This will be the second one of these I've done since I've been a father, and keep up, just trying to keep chugging along, and hats off to my wife. Really deserves most of that credit, but also hats off to a job that she has that permits her to take off extended time on maternity leave, because I don't really understand how people can do this if at least one parent doesn't have significant leave. So very grateful for all of that.
Yeah, it's the society we created doesn't make any sense for perpetuating our society, because we make it so that people can't have kids, and they can't raise the kids. It's really bizarre. We look really highly on where we are in society, but we're not really that progress much if we're doing this the way we do it.
Yeah, nothing to do with a case law podcast, but like the sole reason that we are thinking we'll probably likely only have one kid are completely societal.
Yeah.
Money, time, the fact that the planet might not be around for the second kid, but it might be around for the first kid. So like all those things, completely societal, structural things, inhibiting. So, for those scared about the great replacement theory, those who are at, I'm not even going to go down that path. It was going to be a joke about something that I do not, that I think is absurd, but I'm not even going to make that joke because it's too much.
Well, good to see you. Let's talk federal litigation.
For the record, I don't think I'd actually be considered an asset to those who adhere to the great replacement theory as a Jew. I don't think we're included in the, the desired peoples, the worry of which we're being replaced. I feel like we're doing more of the replacing, but again, I've gone too far in that very academic theory, that very meritorious theory of great replacement.
I hear it.
Speaking of great replacement, let's talk about some immigration. Oh my God!
What kind of stuff you got on your plate this month?
So there were so many good non-citizen wins in September that I I couldn't even. I mean, I can never do all of them, but like I really had difficulty picking. So you have to listen to the Immigration Review podcast every week to get these cases. Some of them on the week by week, I'm serious. I mean, one of the cases I'm not even going to mention is the Ninth Circuit's decision in Singh v. Garland. There are a million Singh v. Garlands in the Ninth, don't get me wrong, but like this one was on the deficient notice to appear, got remanded from the Supreme Court in Campos Chavez. It was done direct certiorari. And the Ninth Circuit just said, okay, you don't like that? Here's this. And they issued just this bomber of a decision on an absentia reopening. I'm not even going to get to it, but like, September was a month. The one I did pick three, as I always do. A non-citizen good, because no need to just discuss the bad again. Discuss the bad on the podcast as well. But the first is Bedos v. Garland out of the First Circuit on September 20th, which is a bit of a unique case, but it made me chuckle. It's about motions to remand. And don't get me wrong, the procedural history of this case is such that like it would be very hard to get this ruling again. But you might not need to get this ruling again now that the First Circuit has issued it precedentially. And it is this. You've got this guy, Mr. Bedos, is from the Democratic Republic of Congo, loses an asylum case deemed not credible, and while on appeal to the BIA, marries a U.S. citizen, seeks to remand his case back to the immigration judge so he can pursue adjustment of status. He has a lawful entry, I believe, as a student. Committed a lot of things that led to that adverse cred finding, but nevertheless wanted a chance to pursue his green card. And the BIA appeal is still pending. It's a motion to remand. It's not a motion to reopen. DHS did not oppose the motion to reopen. They didn't file anything, as so often the motion to remand, not the motion to reopen. DHS didn't file anything, which is technically a non-opposition. That happens all the time. Okay?
Yeah.
But the BIA denied it anyway, and they issued, you were found not credible, and it seems they might have thrown some shade on the validity of his marriage, the fact that they got married during the BIA appeal, all of that. And the First Circuit reversed. And don't get me wrong, I talk about the procedural history. It seems that Oil, the first, waived the argument that the BIA is supposed to, grant these unopposed motions to remand. It seems Oil waived it, and they wouldn't waive that again.
Mm-hmm.
But like Mr. Bedos submitted like 15 cases, unpublished BIA decisions, or like 20 of them over like 15 years. It's not even that many, to be honest with you, where the BIA is granting these unopposed motions to remand. And Mr. Bedos described that as the BIA then, in denying his, having, quote, inexplicably departed from a settled course of routinely granting unopposed remand requests so that petitioners can pursue adjustment of status, end quote. Oil didn't really combat that pretty wild assertion that like it is a settled practice that the BIA will always remand. I mean, I'm not at the BIA. I'm not quite sure that's the case, but like now it is in the First Circuit because they found it arbitrary and capricious that the BIA would go against this settled practice and not just remand it to let Mr. Bedos pursue it, where DHS had not opposed the motion to remand, which again happens all the time. So, like, think about the Bedos v. Garland now. By the way, I've gotten some emails about this since it came out. And I did it on the podcast. Like, when I file these motions, I'll often then, wait the 10, 13, 20 days, whatever it is, plus some days in BIA or immigration court, and I'll often file a motion to deem motion unopposed. Because under the practice manual for the IJ and BIA, and under the regulations, after a certain amount of time passes, the IJ or the BIA has the authority to deem any motion unopposed if no response is received, just like in any court. Doesn't mean you're going to win, but I will follow those motions. And you best believe I'll probably be citing to Bedos v. Garland from now on, talking about how it's a settled course that the BIA should remand under those circumstances where DHS doesn't oppose. Not only that, the First Circuit found that there was error in the BIA to really touch the validity of this marriage at all, given that that is fact-finding, and so you really just got to remand it for the guy to get his day in court on adjustment. So big decision there. And I like it in the back pocket, again, for kind of recognizing this settled
Oh, do you
course.
know who the lawyer was
Granting
that submitted that? It's a good move on that. You
the
know who
what?
the lawyer was that made that charge?
I do, because I always give the props. His name is Gregory Romanovsky in the First Circuit. I've heard his name before, and of course, he's probably using Ben Winograd's unpublished BIA repository. But again, look, who am I? I'm nobody, but like 15, 20 cases over 15 years, isn't that many? But it was a settled course. Now, more than a dozen orders during a roughly 15-year period is what the First Circuit says. Like, all right,
That's
rock
uh,
on.
no, okay. So yeah, we know you finished up. So sorry, everybody. We went on a quick break to do some mic checks and stuff. But okay, so we finished up on the last one, the great case of where the precedent got set like that. That's good.
Oh, that's all the cases I read. I bring only the Bedos v. Garland, the motions to remand. Remember it, and what that means when DHS doesn't respond to your motions. So the next one, and you said that you just learned a little bit about crimmigration. So United States v. Perez Garcia out of the Ninth Circuit. Something to keep in mind for your, now John Khosravi crimmigration expert starting crimmigration practice at the firm. Not you got to look at the non-immigration too, because all of this good law, especially on the crime of violence, aggravated felony, and it's got implications beyond crime of violence, as you'll hear. So much of it is happening in the sentence enhancement context from federal criminal court, where it's a lot of the federal public defenders making these very smart arguments. And that's because of this decision called Bourdain out of the Supreme Court a couple of years ago that I'm talking about all the time, in which the Supreme Court essentially said that in order to be a crime of violence for both sentence enhancement and immigration purposes, again, crime of violence is an aggravated felony, meaning that it takes away a green card or bars you from relief or bars you from naturalization. The state statute needs to have a mental state, a mens rea, of knowing or specific intent. Recklessness as to the force used will not cut it.
Mm.
And that's essentially Bourdain. Now, does extreme recklessness cut it? What is extreme? Who even knows? But that's essentially what's going on. And it's so important because over the last couple of years at the court, they've been really dumbing down the level of force required for something to be a crime of violence. Like, force, it's becoming a lower, lower level, but the mens rea is becoming higher and higher and higher.
Yeah.
And there are so many criminal statutes that permit conviction with merely a reckless mens rea because these states want to criminalize. They want to put more people in jail for, quite frankly, violent things.
Mm-hmm.
And mens rea is almost never divisible. And so here we have Cal Penal Code Section 245A1, assault with a deadly weapon other than a firearm. Sounds like a crime of violence. It's not under Bourdain. And meaning it's not for immigration, for sentence enhancement, all of it, because it can be committed recklessly. And it's actually a very complicated argument. California, what is mens rea? Reckless, what is the mens rea requirement? It's been going on for like 150 years in the California state courts, but the prevailing definition of assault mens rea from the California Supreme Court is an intentional act and actual knowledge of those facts. Well, blah, 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 whatever. It's like, 1950s speak,
Yeah.
but it really equates to recklessness or these general intent crimes. So much is a general intent crime to take you back to crim law 101.
Yeah. The mens rea. It's been
And
that a while.
be right. But don't take anything for granted because of that. I mean, there are so many cases. This decision itself mentions like a half dozen cases, both in the immigration and the sentence enhancement context, talking about that is now, quote, I'm sorry, Bourdain establishes a bright line rule. If a statute criminalizes use of force committed only with a conscious disregard of a substantial risk to another person, it is not a crime of violence. Our prior cases do not apply that test and thus impermissibly categorize, blah, blah, blah. They are not merely in tension with Bourdain, they are irreconcilable, end quote. In layman's terms, that's a Ninth Circuit panel vacating Ninth Circuit precedent, which it's not allowed to do unless the Supreme Court has stepped in with a fundamental change in law. And it's not just about 245A1, assault with a deadly weapon, not a firearm. It's like all of the California assault crimes, of which there's like a half dozen or like 10. They all have the same mental state. Like, even if it was assault, and I'm just making this up a bit, but like, even if it was assault with a gun and a knife at the same time, ridiculous statute, right? It would still just be assault, which again has this reckless mens rea. How many other things in California and other states are just incorporating these old definitions of assault, which are bringing in with them this recklessness mens rea? Because again, states have an incentive, at least they've demonstrated it, to criminalize more conduct. It's taken us out of the crime of violence definition. It's a huge deal. This case alone vacates like 6 precedential Ninth Circuit decisions directly, and probably a lot more just using the logic. And then, oh, by the way, as I said at the end, which is totally not what the court says, but like, what about CIMTs? CIMTs aren't governed by Bourdain. But first of all, to say that like an assault crime is not a crime of violence, but it is a CIMT is a bit ridiculous, right? Because a crime of violence is more culpable conduct. So if it's, how could it be, if it doesn't even satisfy this, how can you say it's like a lesser removable offense? That's a big picture argument. But a little picture argument, as I identified on the podcast when I did this case, since I've been doing the podcast since May 2020, the Ninth Circuit in Safarian had granted Chevron deference on a California assault CIMT case, and the BIA itself in Aguilar Mendez talked about a California assault statute, explained it was a CIMT because, quote, it requires, quote, an intentional violent act, end quote. Sounds like the BIA misunderstood what is required of California assaults. It's not an intentional violent act. And if it's not an intentional violent act, it might not be a CIMT. All this stuff flows from the new analyses after Bourdain. Bourdain is the gift that keeps on giving. For crimmigration, again, I mean, we can beg to differ why somebody who has a assault with a deadly weapon, not a firearm conviction, should get to keep his or her green card. But like, law's the law. That's what we do. A lot of unfair things happen, and the reverse in immigration. Our job is to use the arguments that are presented to us, and Bourdain has created quite the argument for the non-citizen bar.
Actually, that case that we talked about earlier was assault with a deadly weapon, but not a gun, and which would be problematic if it was an adult. These issues in this case would come about Ninth Circuit as well, but it was a minor, and so I found matter of Devison and the federal FJDA or Federal Juvenile Delinquency Act. I'm like, oh wow, I didn't know. For the most part, if you're a minor, everything's all good. If you're in juvenile court, there are like exceptions and nuances, and where the
Yeah, the Devinson analysis is complicated. So is that it's a New York one, right?
Yeah.
But if you're talking about California assault with a deadly weapon, not a gun, you're actually talking about the exact statute maybe that I just talked about. So you should read United States v. Perez Garcia. So maybe there's not even an issue. Juvenile, don't get me wrong, juvenile, that's a better argument. You make both.
Yeah.
I mean,
Backup plan. Yeah. But yeah, I was studying that the FJDC. I was like I didn't even know like that. I thought juvenile was still criminal, but they're like, oh, it could be it's considered civil. There's the way this. I'm like, oh wow, this whole area of law I never touched before. That's really needed, I guess, as it comes up.
Yeah, it does seem too that like the effect of offenses committed as a child is in need of updating by the BIA. The case law is old. Yeah, I've had a similar experience.
Yeah, so it's endless amount of studying in this field. you never leave law school when you're doing this stuff.
Immigration Review Podcast.
Immigration Review Podcast, for sure.
You think that's bad? I'm not even going to do it. But Lopez Orellana v. Garland out of the Fifth Circuit, I had to read it twice. It was so complicated. I'm not even going to do it. Huge win. for pro bono counsel. They sent her back, Miss Lopez Oriana, to El Salvador. Now they got to bring her back and like expedited removal and all the aggravated felony. I mean, Lopez Oriana, it's crazy. Just this month, what happened in crimmigration and in the cases. Lopez Oriana, give it a read if you're a crimmigration person. The Fifth Circuit, not going to do it right now, though. Did it on the, whatever the mid-September episode was of the podcast. That's a September 18th decision.
As a
But
person, real quick, as you are, that's reading these decisions every week constantly. Do you have any tips on how to read them faster, better? Because like I rarely read these. When I read them, it's like I have to stop everything and really focus because It's not something I do consistently. Do you have any tips or is it just you got to read it and try to understand it and keep track of it?
Well, I mean, my podcast, I'm trying to provide, nuggets and practice pointers and stuff. So I kind of got to read them pretty hard and pretty detailed, and really spend that time. But if you weren't doing that, I mean, how much you could skim the facts, right? Like, you're not trying to distinguish the facts unless you've got the identical case. The standard of review, the legal section's not so important. It's like the holdings that they're doing and the analysis that's most. So that cuts off with these cases like a third of it. If you're not paying so much attention to the facts or the standard of review or the generic portions of law. After that, I'm not sure that there's a way to do it quicker unless you're doing it every week like I am. Like I do it so much that like, I don't know, there's 15, 20 issues that I'm reviewing all the time. And so, keen eye to it. But if I wasn't doing that, then I mean, even me though, I read them very carefully because sometimes the most important stuff is like one sentence or a footnote or one citation. You're like, wait a minute, why are they citing? What are they saying about that case? Wait a minute. Like in the United States v. Perez Garcia case, the most important section really is the one ending of a paragraph where they string cite like the 6 precedential decisions that they're saying are no longer good law. The one sentence where they're saying bright line rule, if it violates Bourdain, it's irreconcilable. So I think that is harder.
That's the thing. Like when I was reading these cases, one is like if I try to just go for like the key parts, I'll kind of lose track of who's who, what's going on, and then you got to read all this and check the sites. And I've asked Alexis, and I'll double check it here and there. I'm like, okay. There's one where Ninth Circuit made a decision, and then the Ninth Circuit made another decision, and Lexus had it as red. I'm like, wait, it's the same decision. I'm not sure what was going on with it, but
you definitely can't. You can't trust the flags when it comes to immigration at all. They don't. Lexus and Westlaw don't know what they're doing there. It's a good indicator.
Yeah.
Seriously, do control find on the Immigration Review podcast page where I've bulleted it in such a way that like it's what I use for research. That's only since May 2020. Same thing with Ira's book. You can get it digital. You can do control find and then go from there. I mean, I think it's crazy to be reading all the cases every week like I do. I do it because I've got the podcast. I've got financial and professional interest in doing it now, which was kind of the whole point of the podcast. Give me a reason to do it that makes sense. And it barely makes sense for me, by the way. But other than that, like case law research, really what you're asking is something I talk about with interns all the time. How do you know when you're done? How do you know when you have the answer? And to me, one of the things I've heard that's helpful is like when you start seeing the same cases cited over and over again, you're close. You know what I mean? You start going, that case is citing to this case, and you go and look at that case that's being cited to. You go all the way to the beginning, and then you see then where's the discussion of that case? You find the seminal case, but once you see things getting cited to more and more, and then of course, it's nice that if you're relying on August 2024 to cases, right?
Yeah.
Then maybe check that with the podcast page in Ira's book to see what it gets distinguished, because you can't, if it's the Ninth Circuit, you can't always trust some of the judges. They're going to be saying the law, but they might be painting with a broad brush because that's what they really believe the law would be, and maybe it's just dicta.
Do you have a direct URL for is it immigrationreview.com or what's the best way? Because I know it's on the
It's on the Kurzban website. It's you go to the podcast page and then there's the list of case summaries, and that has every case I've done. So every immigration decision since May of 2020 bulleted. I don't know, 2,000 cases. I have no idea, but with things that with the things that I deem important to them and helps me
Yeah.
find the cases.
Very cool.
For example, United States v. Perez Garcia that I just did, I have it bulleted on that website. Crime of violence, recklessness, Bourdain, Cal Penal Code 245A1, assault with a deadly weapon other than a firearm. So if you did a control find for any one of those single words, you'd get to it pretty quickly. And you'd know it's the most recent Ninth Circuit one. And so maybe that's where you start and save a lot of time.
Very cool. Quite a service. I can tell you did it when the pandemic started, 2020, so you had some time on your hands.
All about that SEO.
Yeah.
No, I'm just kidding. It's not about the SEO. Um, Crimmigration, through crimmigration, the last case is Mazariegos Rodas v. Garland out of the Sixth Circuit, which is it's a big case. And I'm not even touching what the Ninth Circuit said about Chevron deference and Loper Bright
Oh,
in Lopez.
interesting.
I'm doing panels on it, and actually it's not a non-citizen friendly thing, but this kind of touches on that. This one's about family-based asylum claims. And, it's an important case. I like to tell the facts of it in my podcast. I'm not going to do it here with limited time on but it's like these two daughters fleeing terrible gang violence where they were all but abandoned by their parents who themselves came to America. And then the daughters came when things got terrible. And the immigration judge, the Sixth Circuit kind of doesn't paint her in the best light. But like to me, this immigration judge was very upset with the mother who then testified in the case of her daughter. And the quote is, "The mom who left her, I'll have to tell you, I'm going to have hard questions for her." No, end quote. And I get the impulse, right? The parents left their daughters in El Salvador, if I'm not mistaken, and like terrible things happened, and now we have an asylum. Oh, Guatemala, and terrible things happened, and now we have an asylum claim. It's a mess. And so I'm not going to get into all the facts there, but they're compelling. Not necessarily an asylum grant. These things are so complicated, but the young women brought a family-based asylum claim, and it is pretty much the case that family is a particular social group. Attorney General Barr really tried to backtrack on that, but there's nuance, but family is pretty much a particular social group. And so the argument when a family-based claim is brought in asylum has now moved to nexus. Okay, you're part of the family. Okay, we recognize that under asylum law, but that's not one central reason for why they're targeting you. They're targeting you because, you're young women without your parents, or the gang wants money, or the gang wants you to deal drugs for them, that kind of stuff. First of all, just let's take a step back. In the Sixth and the Ninth Circuit, the nexus thing for withholding of removal, the standard is lower. It need not be one central reason. It need only be a reason, which really is like anything. So just remember that distinction.
Yeah.
The BIA said otherwise in a matter of CTL, but that doesn't mean anything anymore after Loper Bright. Some circuits have also said it. Do the research on what your circuit has said. The Sixth and the Ninth Circuit have said otherwise. So from the get-go, this is kind of needs to be remanded for withholding because, again, a one central reason analysis, not a proper nexus analysis for withholding in the Sixth Circuit. But more to the point, in 2023, the BIA, families a particular social group, tried to really make it hard for non-citizens to win on family-based claims in matter of MRMS, in which the BIA said that, quote, to be successful on an asylum claim based on family membership, an applicant must demonstrate that the persecutor's motive was to overcome the protected characteristics of the family or otherwise based on animus against the family, end quote. Really, you got to hate the family. Not necessarily the case for any other particular social groups, but the BIA said that, and more in MRMS, clearly in a desire to stop family-based asylum claims, but in the most egregious circumstances. And here's the Sixth Circuit saying that from, putting aside that we don't owe deference to that at all after Loper Bright, that's just dicta from the BIA. Rather, the BIA said in 1996, quote, in adjudicating mixed motive cases, and family-based claims are always mixed motive. It's always like family and something else, right? It is important to keep in mind the fundamental humanitarian concerns for asylum, and such an approach is designed to afford a generous standard for protection in cases of doubt, end quote. Matter of SP. The Sixth Circuit is saying, no, you don't need to show an animus towards the family to establish nexus. That's one way. Yeah, absolutely. That's one way to show nexus. But in the Sixth Circuit, at least, is where a persecutor's views of the family underlay all of his actions. The motivations are inextricably intertwined. It's like here, that they're targeting the girls in part to the Sixth Circuit because they're part of a family where the parents are in America. Is that so inextricably intertwined with family that you have a nexus to a protected ground? Well, it needed to get sent back to the BIA for further analysis. But what the BIA cannot do is rely on matter of MRMS to say, well, the gang never said they hated your family, so denied. And that is a big deal. This is an analysis to advocate for if you're an asylum attorney in every circuit outside the Sixth Circuit, because no one's touched matter of MRMS yet. It's a big deal. And, just dicta from the BIA, that alone, I mean, it was a split decision from the Sixth Circuit, but that doesn't make it not precedential. And so that's also what happens when you read the decisions every week. Sixth Circuit has had some asylum bangers of late for non-citizens. That is Mazariegos Rodas v. Garland, September 20th.
Very cool, man. Like every immigration section is a niche. It seems like if you do asylum, you got to really pay attention for all these things that are changing up. But thanks for coming on Immigration Review Podcast. Found wherever you are looking for immigration, you'll find it.
Wherever you're finding
We're at
podcasts.
the podcast.
I'm right below Joe Rogan now in popularity. Like Joe Rogan, this girl, this woman that just interviewed Kamala Harris, and then me. That's our top 3 podcasts.
Call her daddy. It's Call Me Immigration Lawyer.
That was the first time I had heard of her podcast, Call Her Daddy.
Yeah, I've only heard about it or listened to it, but Vice President Harris was on there, and so it seems like it's a pretty explicit podcast from what I hear. It's kind of random, but hey, we'll go where the audience is, I guess.
More so because her team has been ignoring my emails for her to appear on the Immigration Review.
I bet. The last thing she needs is going to Immigration Review podcast.
I'm gonna have to. I'm limited to would-be Vice President
JD Vance.
JD Vance, but JD Vance is accepted, but I don't want to have him on.
Early on in the Toolbox, I contacted the head of. There's this one anti-immigration group that's like the number one with it.
Fair.
Is it? Yeah, Fair. It might not be Fair. It's a guy named has like an Armenian last name that's like runs it. I reached out to them. Hey, come on the show. We'll talk. And they never responded. So now I don't care enough. I was going to be a hard-hitting journalist, and then I was like, I changed the direction of the show and just let's stick with talking immigration lawyers.
Stick with the softballs.
Yeah. Why not? Keep life. There's enough complications in life. Let's keep it easy.
Speaking of softballs and hardballs, you watching this Dodgers Padres series? We whooped your butt.
That's why I don't watch the Dodgers, because they're always really good to disappoint. That's why
things got violent. Did you see it? They were throwing stuff at us, at our outfielders, and then they went on like a 6 home run, just like embarrassed the Dodgers. I loved every minute of it.
It's been 10 years since I stopped watching because I was too obsessed with it. Okay. To cut it off.
Well, you should start again. The series tied at 1-1. It's a good series, and you guys have the best player in the history of baseball in Ohtani. So
yeah, it's a good time to watch. I did see like a TikTok on ESPN where they're like, baseball has become like the secondary sport. It used to be the primary sport in America. Now it's like when fall came, it was like October is like baseball month. Now it's kind of like la la la. There's like all this other stuff going on. It's really switched up.
It's true, but the playoff baseball, like playoff any major sport, is fantastic.
Yeah,
and it's stadiums are packed.
Is baseball like there's so many games? I used to watch every game when I was in college, and that was such a waste. It wasn't a waste of time because I enjoyed every second of it, but at the same time, I couldn't get any studying done. I couldn't get any life done. So I'm afraid to get
Yeah,
stuck. It's like video games. I don't want to get start because I'll get sucked into it, and then just, I don't have time for anything else.
you do seem that I wouldn't be surprised to learn you've got a bit of an obsessive personality.
Oh yeah, if I find something, I'll go. Like, if I get a watermelon, I start eating it. I'm gonna eat the whole watermelon. I ain't gonna stop until it's done, all the seeds and everything.
Right, right. Will you be at Ayla, California, by the way?
No, it's up north. Unless it's right next to you, I'm probably not going to go. Or frankly, if you don't invite me to speak, I'm not going to go.
Right.
But
Okay.
I am promoting. We're going to have the main committee member in charge, Maida and Sarge, come on the show. So we're going to promote people to go there. But for me,
Cool.
yeah, it just has to be really close. Ale National is always good because just national is a lot of fun. Once the kids
Yeah.
I'll start flying out this stuff because these events are so cool. I love going. I mean, are you stuck in the house, or are you going to go?
I'm gonna go, and my wife and the will then be a 3 month old. It's gonna be we're gonna do it. I don't know how we're gonna do it.
Plane or car?
Uh, I don't know. I really have not planned well for this. But like it's Monterey, like they've got an aquarium, right? I mean,
Yeah.
I don't know. Do you show an aquarium to a 3 month old? I really
It's
don't know
boring.
what I'm
You
doing.
take our kids there. This is boring. For my honeymoon, I actually drove up to Monterey, and it was cool and everything. But I was like, eh.
I guess. Well, my point is like, can a 3 month old even appreciate a giant fish?
No, that's mostly like the little star plastic stuff in front of their face. Is about it. That's too hard for them to grasp above that.
Right.
Milk and just anything you can grab.
Right. We'll take him to a milk factory.
Yeah, that works.
Get him where he's at.
Well, thanks for coming on the show again. I really appreciate it.
My pleasure. See you next month.
Well, there you have it. The wonderful Kevin Gregg, really good immigration lawyer. Not just immigration, federal immigration. I mean, he does everything. It's amazing how he has the patience with to fly over the country and to fight these fights. But that's why we have great lawyers like that in our field. But if you want to be a great lawyer on the stuff I do, marriage, immigration, consular processing, adjustment of status, know the ins and outs, we got the course for you. We also have this Tag Loan '01 seminar we did. We're including it free in the package right now. We're going to charge separately a ton for it. So get it while you can right now. '01, marriage, immigration, start your practice, switch over, or start your own firm, and really get the good stuff. We've been doing it for a lot of years. You want to learn based on statutes and just have camaraderie, our community page, and our monthly office hours. Hit me up, info@immigrationlawyerstoolbox.com. Again, that's info@immigrationlawyers with the S, toolbox.com. And we'll have a chat to see if the course is for you, and we'll get you in. We have a lot of happy customers and happy colleagues that are in it, and just want to increase that and just develop what we're doing here, make a better practice area, make the top of the line lawyers and all the different lawyer fields being immigration lawyers. Until the next one, have a good one.